Okay, well, some of you were just with me, so sorry you have to listen to me again, or maybe it's exciting, I don't know. But like she said, I'm Rachel Van Tyle. I'm the Director of Legal Services at Exodus Refugee Immigration. We're a refugee resettlement org in Indianapolis. And I am in charge of our 7-person legal team there. So we have 4 attorneys, 3 legal assistants, but 2 of them are also DOJ reps, and then I have 2 additional DOJ reps. So we have, we're a growing team, given that in November of 2020, that was our first legal team hire. So in the last 3 years, we've expanded quite a bit, which is exciting. So more background about me if you didn't hear this already. I have been doing this 12, 13, I don't know, I'm starting to lose count, something like that years. Spent the first 10 years of my career at an organization in Indianapolis called the Neighborhood Christian Legal Clinic, which provided pro bono immigration services, among other legal services that we provided. And I've been at Exodus for the last 2.5 years. Today the plan is to talk about initial consultations and that, like, things to think about, red flags to think about, but also I feel like this discussion really needs discussion. So I want you to say, oh, but I had a case like X. Tell me what you think about this. I really think that this is the way this particular level of this case needs to go, this class. Plus I like interruptions. I mean, I don't like interruptions, but I like you to raise your hand and tell me what you're thinking, what questions you have. I prefer kind of a more conversive style of teaching. And I'm also going to go over a little bit about inadmissibility and deportability at the end, so you can think about those red flags as you're doing consultations with folks, okay? So I'm going to start very basic. I realize this is like a more advanced course, but I still think it's good to kind of review the basics. So when I think about doing an initial consultation, I think about what client data I want to gather. You really want to be, I know most of you are fee-based, right? In my area, we're grant-based a lot, so we want to think about data that the client, the grantors may want. But you may also want that in order to kind of present different statistics about your church or whatever, like what's the average education level. So think about the client data you want to gather before you meet with a client. And I would say, the first of the year is a great time to start gathering a new data. So we gather information, not just a number, an address, and phone number, and things like that. We gather preferred language, preferred communication style. So are they want me to message them on WhatsApp? That's fine. We gather education level, like I said, employment level. So are they full-time employed, part-time employed? In part, that's also to verify income. So I'm not serving somebody we don't charge for our services at Exodus who makes $600,000 a year. But also just to kind of think about the kind of statistics and the story I want to tell about the legal services that I provide. So that's just my mindfulness to you. We have a script. Our legal assistants have a script based on what the client says their desired outcome is of questions to ask. One of those questions is always, have you ever been arrested? Have you ever been in the back of a police car? Have you ever had handcuffs put on you? Because clients don't lie on purpose. Normally, they understand the question, I feel like, a lot. If you say, have you ever been arrested? No, I've never been arrested. Maybe they don't know what arrested means, and they're not going to tell you they don't know what arrested means. Were you in my presentation last year? He told me a good one last year, and I still ask it. Have you ever been in front of a judge? Which I have never asked before until I came to this last year. So see, I can learn things from everybody. So these are good ways to ask if anybody has any criminal issues in the background. My fervent advice to you is, I, as an experienced immigration attorney with 12 years of experience, don't touch criminal matters. I refer those to folks who have experience in both criminal and immigration cases. Now, if you're talking about a speeding ticket, okay, fine. But if you're talking about really anything of significant criminal issue, you need to be referring that to a private attorney that handles both criminal and immigration, because in particular, if you're DOJ and you're not an attorney, you are not authorized to give advice about any criminal matter anyway. So you should not be really touching that. That is But like I said, I have that law license and I don't do it because it scares the crap out of me. So I like to guess I like to do it in my head, but I don't tell the client because I'm like, I wonder, and then I call the attorney they called and say, hey, I'm their pro bono counsel. Can you tell me if my analysis was right on this, just because I like to know. But you want to issue, spot, and identify the questions to ask. I lead my consultations in terms of, I do what I call like a goal-oriented intake. So I ask them what they want to accomplish, and then I back the questions up about that. I don't do, here's 90 immigration questions, let me ask you that. Because otherwise, intakes get off the rails real quick. And then they're telling you their whole life story about this one time that this one thing happened, and it has nothing to do with what they want to accomplish. That being said, you also need to ask additional questions beyond what they've thought. So if they're saying, for example, if they come in and they say, I want to apply for my green card, and I want you to do it through VAWA. You're not just going to take their word for it, right? You need to ask them the questions about why they might qualify for a green card. So I say that with a little bit of a caveat. Goal-oriented, but what's the ultimate goal, not how do they plan to get there? Because we don't go to the doctor and say, I have heartburn, take my heart out. Like, no doctor would do that, right? Obviously. So we need to think about ourselves in the same way. I think it's one of our duties to provide client advice, regardless of whether you have the capacity or the ability to take on a case. And sometimes that advice is, this is beyond my expertise level. You need to seek another attorney's counsel. I had to do that this week with a student visa related issue that I did not know. I said, this is beyond my expertise. So my advice to you is to go and seek this other person who has more experience in that. And then, you have to decide whether you have the capacity to open a case. Non-attorneys cannot really direct the caseload, ethically cannot direct the caseload of people taking cases, even though you're not an attorney. So like, it can't, a non-attorney boss cannot say to you, you must take this asylum case. You really have to have that autonomy, and I hope you all have that autonomy in your own agency to, with some exceptions. My non-attorney boss tells me I have to do so many green cards a year, but he doesn't say you have to take this green card in particular. So there's ethical issues with that, just be aware. And then make sure I said it last time, 97% of this job is client communication and managing client expectations. So whatever you are doing, make sure you are clearly communicating that to the client, as far as like even spelling out steps to the, like, I'm going to file your I-730 for you. I will respond to any RFEs that come in. So that when they call you and say, oh, but now you're my attorney, and now you're going to help me with my green card, and you're going to do my citizenship, you say, that's not what we contemplated. I remember that letter I showed you, it just has these two things. So it gives you an out if a client's difficult, or you don't have the capacity to do something beyond what you promised to do 18 months ago. Your life could be different 18 months later. You may not have the capacity to then also do the green card, or also do the citizenship, or also do the work permit. So like I said, with initial data, this is some of what we do. I really think language spoken is really important because, especially with like Central Americans, they may do it in Spanish, but maybe their best language is Chu. We need to be mindful of indigenous folks and their language, and what potentially their best language is, but also a language that they can communicate in. So I think you need to be mindful of both. And then I ask, what is your goal here? Why are you, not why are you here today? Because then I'll be like, well, my friend told me that this happened and blah, 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 and 20 minutes later you still don't know what the goal is. But I say, what's your goal to accomplish today? I want to find out about getting my citizenship. Great. Then I ask questions about citizenships. I want to become a citizen. So that's the question. These are the kinds of questions that I ask. How long have you had your green card? Because that's question number one, right? Does anybody know the special rule? We just did refugees. Anybody know the special rule about refugees and green cards? So 1 year to apply, that's true. But in terms of citizenship, they are 5 years towards citizenship starts counting on the day that they enter the U.S. So they get backdated green cards to the date of entry to the U.S. So you apply for a green card today and it gets approved, let's say get approved today, and you're thinking, oh, it's going to be backdated a year, but it's backdated 3 years to when they entered. Totally normal. So refugees, 5 years towards citizenship starts counting at the point of entry as a refugee to the United States. Asylees get backdated a year from approval, so they get 1 year of credit. So they technically only have their green card for 4 years. Also, never ever take the client's word for it on how long they've had their green card, asked to see it, because I really don't mean to say that I think clients lie. I just think that they misunderstand and they don't know, and they might be a refugee who's had their card a year, but it was pending for 4, so they've got enough years on their green card. So really what we're asking is, what's the date of residence since on their green card for their citizenship? Any criminal history. Why? You have to have good moral character to apply for citizenship, right? And you can't have had any significant, I'm teaching the citizenship thing tomorrow with more detail about good moral character, so if you want to come to that, come see me tomorrow. But these are some of the ways I ask. Have you ever been arrested? Have you ever been in touch with the police? Have the police ever put handcuffs on you? I had a client, a refugee client, who we got called for an interview. Getting called for a green card interview when you have a refugee is not a very good sign. That usually means there's a red flag somewhere. So I will tell you that I had this client, and I asked him this. I said, have you ever been arrested? He was like, nope, never been arrested. I'm like, why are we going for an interview? I don't know. We get there, the officer says, have you ever been arrested? He goes, nope, never been arrested. She goes, have you ever talked to the police? No, never talked to the police. Have you ever had handcuffs put on you? Oh yeah, that one time. Have you ever been in the back of the police car? Oh yeah, I did go in the back of a police car. So I don't think it was that he was being intentionally deceitful. It was there that I realized I had to work on how I ask questions. So now I add the question of, have you ever been in front of a judge? Because sometimes people don't realize that also happened. And it doesn't mean that because they say yes to, they've had interaction with the police, that they're ineligible for whatever benefit they're seeking. But you need more information, and that you have to, initial intakes are how you get the information you need to make decision on whether the person's eligible for the benefit they're seeking and whether it's a good idea to file. Because part of it is, yeah, maybe they're eligible, maybe it's a terrible idea to file. You know, if they're theoretically eligible for a green card, but they've got, you know, a really nasty DUI, they might get put in removal proceedings. And so you need to decide whether that is it's a good idea for them to apply or not. Yeah?
It's more like just kind of confirming.
Sure.
So even if a client expunges their record, they still have to...
That's a great question. Yes, they still need to disclose that. Expungements do not work for the purposes of immigration. Immigration can see through an expungement. Expungement works for employment, and expungement works for getting an apartment. Expungement does not work for any immigration benefit. So maybe that's a question I add to my slide. Have you ever had anything expunged from your record? Because they may think, I don't need to answer yes because they've been told by their expungement attorney, which is not inherently wrong, that they don't need to say yes to they've been convicted of a crime. But that's a question I think I'm going to add, so thank you. See, I learned something.
Also adding that we have a record sealed.
Oh, that's a good point too.
And or expunged, ask both.
Good point. Yeah, thank you. Okay, got 2 new questions. Okay, so I don't want to go into the depths of like every kind of case type. I'm going to walk you through the questions I ask for various case types, but I will teach the session on citizens, so anyway, that's kind of the goal of this training. But if you need me to stop, let me know. Okay, I want to apply for TPS. What kind of things do you need to know? You're thinking about the elements of the benefit that they seek and how to ask those questions. What's your country of citizenship? Mindful that citizenship and country of birth, not always the same thing, right? When did you enter the United States? Because remember, there's a date in time for all TPS applications that they had to have been inside the United States Like, it's not the same date and time. For example, Venezuela was redesignated last week. They have to have entered the United States before July 31st, 2023. So if you say, when did you enter? Also, don't take their word for it, because you're going to have to prove that they entered before a certain day. And they say August 2nd, 2023, they're not eligible. Red flag, right? Yeah, go ahead.
So that one was just reinstated in Venezuela. What do you do if they were out of status for a period with the other TPS when then this one comes back around? Is that a good thing for them? If they were-
Potentially, yeah. It depends on why they fell out of status. Did they lose their TPS because they had a criminal ground?
Well, they weren't there at the
Oh,
time.
yes. Oh, so it's particularly with Venezuelans is what you're asking me? Yes, yeah. So they could apply now even if they've been undocumented for a period of time because they entered without inspection or they entered and yeah. Again, we want to ask about any criminal history and about current immigration status. Afghans are eligible for TPS, even though they had parole and all other kinds of benefits. So don't exclude a benefit of TPS or any kind of benefit just because somebody has some other status. I will also say, I think it is important, they say the goal is they want to apply for TPS. That's not really the goal. The goal is I want to stay in the United States permanently, right? So you start to, say they don't qualify for TPS. Say they entered August 2nd. Then you maybe ask questions about, do they qualify? Have they ever been the victim of a crime? Have you been the victim of a crime in the United States? Tell me about that. Maybe they entered August 3rd and they were the victim of an armed robbery and now they qualify for a U visa. So you don't want to take the client's word for it when they say, I want to apply for TPS. I mean, explore TPS, but also think about what it means to get TPS. It means to remain here permanently with work authorization, right? Or temporarily to permanently. TPS is temporary, but that's not what they want. So that's why I talk about goal-oriented intakes. What kind of questions do you think we should ask about green cards? If somebody says, I want to become a permanent resident. Yeah.
If they have any family members?
Great.
Residents, or if they're married to any citizens?
Citizens are permanent residents. What about what their current immigration status is? How did they enter the United States? Have you ever overstayed before? Do you have unlawful presence in the United States? We need to know that if somebody's going to apply to adjust status or if they need a consular process. 601As. Again, you will see a recurrent theme, criminal history. We have to know about this because it influences our decision and in our advice as advocates for our clients, right? And our job is to be truth tellers. It is not to give the client what they want. I mean, it is kind of, but right? Like, it's more important that you advise them correctly about any potential consequences than you do what they want. So I want to get my green card, but I have a open charge for aggravated assault. Do not touch that. Say, I understand that's what you want, but it cannot be done. You are putting yourself at immense risk, and I will not do it. Because the second you do that, you know what they're going to say, and then they get this terrible RFE, and they're going to be like, I told you about that, and you did it anyway, even if you feel like you were backed into a corner. So you have to stand your ground when you don't feel comfortable taking a case. Okay, what about asylum? Anybody here do asylum? Asylum is my bread and butter, so I know that that's not a thing we all do, but what kind of questions do you want to ask even if you want to know if somebody qualifies for asylum? Yeah?
What does it mean to overstay?
Oh, good question. Let me back up. Have they ever, so if somebody enters on a visa, right? Typically when you enter on a visa, you have a limited amount of time to remain in the United States. Your visa may be good for 10 years, but you're typically given, like on a visitor's visa, about 6 months to enter. Sometimes less. If you've been in and out for 6 months at a time, you're going to see Border Patrol give you like 3 weeks to enter. If you stay beyond the time that Border Patrol says you can stay, that's technically an overstay. And then you're undocumented or present without permission, and you can be placed in removal proceedings. So if you accrue so much unlawful presence, 180 days, you're subject to a 3-year bar from re-entering the United States. If you overstay a year, subject to a 10-year bar. If you overstay for a year or more, leave, try to come back, you're subject to a permanent bar, which is potentially waivable after 10 years. So that's all very nitty-gritty, but to overstay is to say you were here without permission or parole, or permission to be in the United States, or beyond your permission. Okay, asylum, back to asylum. Okay. So asylum, many things have deadlines, right? When did you enter the United States is an important question for asylum. So even if you are going to not take the asylum case, maybe you're just trying to decide if it's even a good case to refer out. These are the kinds of things you want to know about asylum. When did you enter? You have to apply for asylum within 1 year of entry to the United States. There are a lot of exceptions to that rule, but I feel like in the law there's more exceptions than actual rules. So just know that, but generally we want to be applying within 1 year. So somebody who enters on February 28th, 2023 has to apply by 27. It's the day before, so 2/27, so it's 364 days. Does that make sense? So, which means it has to be in the hands of immigration by that day. It cannot be in the mailbox on that day. It has to be in the hands of immigration by, let's say they enter today, by 9/25/24, must be in the hands of immigration. So just FYI. Are you afraid of returning to your country? So maybe they walk in and they say, I'm afraid to return to my country. You're going to evaluate for asylum. What do you think will happen to you if you return? They're going to kill me. Who's going to kill you? Why are they going to kill you? Because they have to meet the definition of an asylee, which is a person who is afraid to return to their country based on persecution on account of one of the 5 protected grounds, which are race, religion, nationality, political opinion, and particular social group. I can do that slower if anybody needs, but and they have to be able to prove that their country is unable or unwilling to help them. So we need to know, it can't just be they're going to kill me. I was just speaking with somebody before about Haitians, and I have just such a heart for like the Haitian crisis and what's going on, but I feel like I do these asylum evaluations for Haitians, and it is just abysmal. It's, who are you afraid of? I don't know, everybody. Why do they want to harm you? They want to harm everyone. Is it because anything about you in particular that they want to harm? No, it's just I was in the wrong place at the wrong time. That is not grounds for asylum. So you really need to suss out this information. I would even argue that, say you're going to refer this out to another attorney. If you gather this information and you send them a synopsis, I would love you forever if you've already kind of sussed this out and said, hey, I'm going to refer this person to you to come talk to you. Here's what the information I've already gathered that will really help us in prioritizing and saying, oh, this person might actually have a good asylum claim, so we should definitely book them for longer or talk to them more, versus us kind of having to do the preliminary investigation. Yeah.
As partially credited reps, we're basically should only deal with.
Correct. That's right.
There's a lot right now, people coming in, and they might have some kind of a semi-parole thing they've gotten coming across.
So like immigration court, yeah,
Yeah,
it's true.
Somebody's told them, here's a I-589, fill it out, bring it back, and bring it does. Like, well, we shouldn't fool with that really.
That's true. Are there any, in Immigrant Connection, are you all partially accredited? Is anybody fully accredited? Okay, and I know we got one attorney back here that could potentially do it. I don't know if anybody else is an attorney, but. Oh yeah, I would agree. If they're coming to you and they're saying, somebody told me to fill this out, you really should not be messing with it unless you plan to file it affirmatively. And you really can only file affirmatively if they entered on a visa and there's, that. Is there an asylum session this time too? No.
Last year was heavy, so we could use it again.
Okay. Well, we can talk about asylum if you guys want, but yes, I would agree. So you really need to be careful about asylum. But I still think you could gather this information and even if you just type it out and you give it to him and you say, call these 3 people and tell them you have a case for asylum and give them this information, I would be if you were referring to me, I would be immensely grateful for this information. Because you've already done sort of so at my office the legal assistants do a preliminary thing, and if there's nothing there, they come and talk to me, and then I say, my legal assistants are also partially DOJ. And then I tell them, okay, we'll tell the client there's really nothing there. They're welcome to meet with me, but there's probably nothing we can do. But if they gathered this information, and then I would say, oh, it looks like they might have a good claim for asylum. So let's make sure we get them in for an hour, and let's get an in-person interpreter. We might do a few things differently if I have this information already set up. Okay, yeah?
I was just going to say something to help figure out if it's defensive or affirmative. You can always just check their A number online, and it'll tell them you if they have a court date, and then that court date's they're in removal proceedings, and then it's just defensive. So
Yeah.
A lot of them don't have court dates yet.
Yeah, it's true.
Nothing.
But that's also been the case where they do have court dates and they've already.
And they're
filed
fake.
asylum and then canceled court dates.
Oh, yeah. EOIR is a mess. Yeah. Do you know I heard a statistic this week that there's 1 million cases in the affirmative asylum backlog? There's 2.5 million in the court. There's 1 million in the affirmative asylum backlog. I know. Not to bring the room down. Sorry, guys. Defeat. But,
But like what he just referred to.
yeah.
If they come across the board undocumented, it's going to be a defensive situation.
Correct.
Okay. So that's,
I would say,
even if they don't have that court date.
even if they don't actually have a court date, yeah. I think you really need to be thinking about people that entered with some sort of visa, or Afghans are such an anomaly situation. I don't even want to talk about, I do want to talk about Afghans, but you know what I mean? In this context, I don't want to talk about them because they're so a one-off population. In general, Cubans are. And now it's more complicated for Cubans than it was a few weeks ago. I know. Can I explain the Cuban situation? Sure. I mean, I can try. Castro bad. No, I'm just kidding. The recent thing that happened with the Cubans.
Yeah, because they were paroled earlier, but now they're re-paroled.
Okay.
But they also have a court date in the removal procedure. So if they're paroled, why do they have court hearing for removal procedure?
Because they're paroled, but not the kind of parole that they want in order to become a green card holder. So there's, okay, this is definitely in the weeds, so if you don't understand this, I will try to back up. But, okay, so there's two kinds of parole. There's 220A parole. There's, 220A, 235 parole, and there's 212D5 parole. 212D5 parole is humanitarian parole. It is what the Afghans entered under. It is what humanitarian parolees enter under. 212D5. Also, you'll see it designated as DT. That's also parole. D as in dog, T as in Tom. DT. Don't know what it stands for, couldn't tell you, but DT is also 212D5 parole. If a Cuban enters with 212D5 parole or DT parole, even if it's only for 60 days, they qualify for Cuban Adjustment Act. There was an argument that 220A, 235 parole also constituted parole in the context of the Cuban Adjustment Act. The BIA said no go, that's not true. The argument was that immigration has two options when they encounter a person who's subject to mandatory detention, and Cubans as arriving aliens are, that they have to detain them or they have to parole them. And so people were using this I-220A document, this 235 parole, to say they didn't detain them, so therefore they must have paroled them, so therefore they're paroled under the Cuban Adjustment Act and they're eligible for Cuban adjustment. What the BIA said is 235 parole is not what is contemplated in the Cuban Adjustment Act. 212D5 parole is what is contemplated. So unless they have proof that they entered with 212D5 parole, then they are not eligible for the Cuban Adjustment Act. So that's what happened.
So we have to check if they were paroled on
DT or 212D5, yeah. If they have that 220A, they did not get the right kind of parole in order to be eligible for the Cuban Adjustment Act.
So what's the next step for 235?
Asylum, probably. Which, if they're in removal, you should not touch, as well, you can't touch as partially accredited folk, right? But I think the Cubans, arguably, as opposed to many of the Haitians, unfortunately, probably have pretty good cases for asylum. A lot of the Cubans. It's just so much easier to do Cuban adjustment if we can get it done, right? So, yeah.
Onto something a little lighter, maybe.
Can I just make sure nobody else has any questions about that Cuban? And are you gonna, or was it Cubans?
No.
Okay, just hold on your question for 1 second. Sure.
Can you describe what the 235 parole is?
So basically, it's saying sometimes ICE has to say we don't have enough beds to detain these folks, or it's not a good reason to detain these folks, so we're going to let them out pending removal proceedings. So that's 235 parole, but it's not strictly humanitarian parole, which is what. Now, I will say, USCIS does not necessarily take the same position as EOIR on this 220 versus 230 or 235 versus 212 D5 parole. So there has been some success filing with USCIS where the person's not in removal proceedings. I don't know. It all just happened like 3 weeks ago, but I have heard of a couple of cases being approved at the USCIS level for somebody who was not in removal, who entered with, and proof of parole was 220A. The adjustment, yeah.
Usually if they have the 235, they're going to have a monitor, they're going to have ankle monitors or phone tracking. And have to
I mean, sometimes, but not always, right? They could be,
Houston have had that.
yeah, they can, I mean, in Indiana, we're not seeing all the folks on ATD. Many of them are not on alternatives to detention, so phone tracking or ankle monitors, but they did enter with 220A.
But they're not automatically removable?
That's another complicated thing. They should be in removal, but if their NTA doesn't get filed with the court, then they're technically not in removal. It's the charging document, right? So if the prosecutor says, I'm going to charge you with XYZ, the prosecutor never files the document with the court, have they actually charged you with XYZ, right? So that's the context. Sure.
So if they get, so as you said, like in certain cases USCIS is doing AOS even for 235. Is that it?
I mean, yeah,
So
that's what I've,
if they have a green card, let's say they do get approval and go through the entire process, but they will still have a pending removal process.
if the NTA gets filed. Yes, I have that case right now. I have a client that I filed, she actually has her green card. I filed a motion to terminate with the court because she had 212 D5 parole, thankfully. But yeah. Sure. You have a Cuban question? Did you raise your hand? Yeah. Okay, you were just stretching. No problem. I'm sorry. I don't mean to call people out. Okay, any other Cuban adjustment 235 parole questions? We can come back to it. Okay, go ahead. I'm sorry.
No, that's great. I didn't know there were other questions. So I'm struggling to figure out, I've had, on my last 3 plant visits for one of the plants, I've had 43 Haitians with TPS who want green cards.
Okay.
And I'm trying to figure out how to use my time wisely with the client intake because, like, I'm just telling them the same thing and they're all getting angry at me.
Sounds about right.
I don't know, I don't want to tell them, because they're saying, well, how do I get a green card? And I'm like, well, there's a few ways to, there's U visas and, if you
Yeah.
get a victim of crime, but if they have it, then you have it. They can apply for asylum, but I don't want to suggest it if they don't really have a decent reason either, and I don't want them to make it up. I'm just trying to figure out how do we, as people representing people in that situation, specifically TPS from Haiti, if that's something that you've seen a lot, like what do you suggest to them, or how do we figure out how not to waste Tyson's time and our time?
Yeah. In situations where you have very similar situated people, like they're all kind of the same, I sometimes like to do like what I call like know your rights presentations or community presentations to the extent that they're available. Like if you could gather them in a lunchroom and say, hey, I know a lot of people have similar questions, and then you could still offer individual consultations if that's what you wanted. But a lot of times, like say I had 30 Venezuelans and they all want to know about TPS. I'm not going to, I think it's right. If you're going to tell 30 people the same exact thing, maybe it makes sense to have them all in a room and do it at once.
I just don't want places to take that many off the line at the same time.
Oh, well, that's about, but maybe you could do it in smaller groups too, you know, something like that. You might think about that in terms of communicating information. I think you have to think about your population, but sometimes, you know, flyers or things like that can be helpful. But like, I don't know how well Haitians, what the literacy level, I mean, is in Haiti, right? Versus like in Afghanistan, I could print all the things in Pashto and Dari and not a soul is going to be able to read it because they speak like 17 languages, but they don't learn to read and write. So I think you have to think a little bit about, whereas if I had a bunch of Venezuelans, I might write things in Spanish because I think the literacy level in Venezuela is higher than maybe the literacy level is in Afghanistan. So I think you need to think about your population, but also consider writing a flyer of like, here's the basic requirements for TPS, or here's the basic requirements for asylum. Ultimately, your job is to advise them of the consequences of a frivolous application for asylum, which is permanent immigration bar. Like you're never getting any benefit, you'll be deported from the United States if you are found to have committed a frivolous application. Reminder that frivolous and weak, not the same thing. So if they really want to go ahead, you don't have to do it, but I do think, I would argue you need to inform them of that possibility and of the requirements for it, and then it's ultimately up to the client to make the decision in their own case. So I don't think it's, I think I always talk about all the options to a green card. So if somebody comes to me and they're like, I'm from Haiti, I'm on TPS, I want to get a green card. And I said, okay. So I asked them all the questions. Do you have a family member here, any family here who is permanent resident or US citizen? Have you ever been the victim of a crime? How did you come to the United States? Did somebody arrange for your travel? Did they pay for it? Were you promised a job when you entered? These are trafficking questions, right? Have you been the victim of a crime? We talked about that. Then I say, are you afraid to return to your country? And we go through that. And I say, okay, well, the questions I asked you were related to family petitions, to petitions for people who are victims of crime, for people who are victims of trafficking, and related to asylum. I don't think you have a very good case for asylum, and here's why, XYZ. You lived in Chile for 6 years and you were a citizen of Chile, and you're not going to be able to prove, even if you are afraid to go back to Haiti, you're not going to be able to prove that you're afraid to go back to Chile. I lay it out for them. But ultimately, they have to make the decision for themselves. I also always advise about the consequences of a frivolous application. So I say, if you are found to have lied on this application, you will never receive a benefit from immigration and you will be deported, like no holds barred. There is no way for you to get around that. So I can't submit an application that I think is, if I think you're lying, I'm not going to submit it. You may also not have the capacity to submit it or the ability to submit it if you're not fully accredited. But you can still advise them of the option for asylum and the requirements for asylum, but also point out the weaknesses in their case.
It's probably then dangerous or bad because a lot of times they want the green card so they can get parole to go back to their country, but they're afraid of their, like that doesn't
Right, that doesn't work.
Right. Okay.
Right, so if their goal is I want a green card so I can go back and visit, then you need to tell them with asylum that's not a thing. You can't do that, right? But I do think you need to present them with all their options. And just because a case is weak does not make it frivolous, does not make it wrong to file it, but the client needs to be aware that it's a weak case and you're unlikely to be successful. Honestly, if I have clients from Mexico that want to file for asylum, I tell them that their chances of success are near zero. Not totally zero, but it's not likely to be successful. And that's not because their claim is not valid, it's because of the inherent bias I think that there is against Mexicans. But I still might pursue it. We don't change case law, we don't do that until we start to pursue cases and do things, right? Maybe that's not your job as partially accredited reps, but we have to be able to present cases even if they're a little bit on the weaker side or change the arguments a little bit, or else nothing ever changes. So, okay. Any other questions before I talk about family, very briefly, family reunification? you would like to hear more about family reunification, particularly for refugees or asylees, see my last presentation. Okay, I want to bring my family to the US. So what's our current immigration status? There is a chart that exists that was in my last presentation called "What part of legal immigration don't you understand?" If you Google that, you will find a chart, and I find it immensely helpful, especially if you're just starting, to remember who can bring who. So I want to bring my sister and I have a green card. Can you bring them? No. That chart will remind you that they cannot bring their sister because it says, I'm a US citizen, I want to bring my sister. Okay, you can bring your sister, that kind of thing. So if you, I will make sure that gets sent out, and I'll include it with these materials too for this session. So you want to know what their current immigration status is. Generally for family reunification, let's put refugees and asylees in a silo, they have to at least have their green card or be a citizen, right? So if they're coming to you and they're like, I have TPS from Haiti and I want to bring my daughter, you're going to say, I'm sorry, you're not eligible for family reunification until you are a permanent resident. Except for the fact, there might be a little program coming for the children of Cubans, Haitians, Nicaraguans, Venezuelans, and Ukrainians. So that was announced last week. I don't have all the details on that, so I don't want to go into that, but just, put that in the back of your head a little bit. When did they first enter the United States? This is important if you're thinking about, particularly if you're thinking about 730s. So 730s are for refugee follow to joins. They have to happen within 2 years of arrival in the US, so that's an important date. Who do they want to bring to the United States, and what is their relationship to you? I want to bring my cousin, Jose. I'm sorry, there's zero pathway for any cousin to come to the US. So, right off the bat if they want to bring their cousin Jose or their nephew. Unfortunately, there's no path for nephews, cousins, grandchildren. How old is this person that you want to bring? Because obviously if they're your kid and you are a permanent resident, you want to know how old they are, right? Are they married? Permanent residents can't bring married children, so you need to know if they're married or not. This person that you're trying to bring, this is information we're gathering about the person I want to bring. Where are they located? They're in Iran and they can't get out. Okay, not impossible, but you want to think strategically about how you're going to do that. Can that person get out of Iran? Because remember, there's no US embassy. More often than not, they're in Afghanistan, and I want to bring my sister's kids from Afghanistan. They're still in Afghanistan, and I need you to bring them. Well, the US has no presence in Afghanistan. There are some limited evacuation flights, which I discussed in my last presentation. But they are, until that person's a citizen, they can't bring their sister or, anybody else. So reminding them of their limitations on who they can bring, managing client expectations, 97% of this job. Clearly communicating, managing client expectations. I feel like that's 97% of every client-facing person's job is controlling the expectations, but things like that. Okay. So I need my work permit. Ooh, I didn't tell everybody in this room, but who wants to hear the good news about work permits? Let me give you some good news after I give you the million cases in the backlog bad news. So last week when Venezuela was announced, in the expansion of TPS for Venezuela was announced, tucked in there a little, I had to read it real thoroughly, was this notion about EADs. EADs are going to be issued starting October 1st for refugees, asylees, asylum seekers, adjustment applicants for 5 years instead of 2 years. So this is great news if you work with these populations, because then they're not going to come to you every 18 months and say, I need a renewal. Theory is that they'll be able to process more quickly if they aren't trying to do them every 18 months or so. Also includes granting cancellation and removal or withholding of removal if you deal with any of EADs on that basis. So that was a little nugget that was tucked in that was real good. We like that. They're also going to try to reduce the median processing time to 30 days. Do I believe it? No, but I'll believe it when I see it, right? So remember, you can't take the client's word for anything. So if they say I applied for asylum, let me finish my thought and then I'll go. You need proof. You can't just be like, oh, I have a green card pending, and just be like, okay, here's your 765. Like, you have to have proof of everything. I like the proof at the intake because I don't want to like spin my wheels and then find out they don't actually have this pending asylum case that they think they have. Go ahead. Go ahead. We like tangents in this session.
So, how or what do you do to stay up to date on all of these changes? Like, I subscribe to a lot of listservs, but it's kind of like an overwhelming number of emails to read them all. Like, do you have a favorite? Because you are up to date on a lot of things that have happened just recently. Do you spend a lot of time reading listservs, or is there a specific one that specific one or two?
I don't know. So some of mine are attorney specific, so that's hard. I am affiliated with, my like organization is affiliated with Church World Service, so we get like kind of breaking news updates from Church World Service too. I don't know.
It's really good about sending out updates like that. Like,
Clinic?
That's
Yeah.
where I find it all. So like I already heard about that and read it. But Clinic is really good. Like as soon as there's an update, you've got an email like within 24 hours.
Honestly, I'm also in a lot of Facebook groups for like various things, like immigration attorneys serving Cubans, immigration attorneys serving Venezuelans. Like, I am in a ton of social media groups, and that's how I get a lot of info. It's not like, they usually say you have to be like an attorney or a DOJ rep to be in that group, and like they do vet you. But it's how I get my anecdotal information. It's how I know that some offices are still granting it after 220As because it was in this group. So that's also a way I get it. But I also spend a lot of time sifting through listservs, trying to understand. Yeah.
Well, that just brings up another question. How do you deal with, I guess, TikTok advice?
Oh, girl.
Constantly doing that. Well, there's this new video out, and this is what happened. This is what my friend did, or
Yeah. Or before TikTok, it was my brother's cousin's friend did this, and he got his green card in 12 hours. And you're like, oh, well, then you should call that attorney. Yeah. That's interesting. I try to remind them that, like, I'm not that person. I don't know exactly what they're talking about, but let me give you the information. I think also we should feel confident that, if you feel confident you're giving the correct information, you should here's some places you could seek a second opinion if you're confused or you want more information. I 100% of the time will give them a list of accredited groups. Like, I don't want them to go into notarios, right? But like, here's some people in my area that are good immigration attorneys. Sometimes they're going to charge you a consultation fee, but if you would like to seek a second opinion and then call me back, that's fine. Because you and I might not have the same idea about how to approach a case, and that's also okay, right? Doesn't mean it's wrong. But regarding like online stuff, I'm like, unless you can be that person's individual client, we can't talk about it because each case is so different that I can't even entertain that. I just like try to move them off of it, but it is hard. Yeah, it is hard. I know. It's the battle of the ages right now, the TikTok advice. The arreglar sin salir, like, I want to punch those people sometimes. So I thought other words, but punch seems at least like most innocuous there. Okay, more questions about any of this? I want to get into inadmissibility and deportability a little bit, because I want to talk about those red flags. But before we move on to that, any other kind of general questions about intakes? Anybody have any things that they do that they feel really work for them? No? Okay. Great. Sure.
So is my understanding wrong or right about that if you are filing immigration under humanitarian grounds, you can have multiple benefits, and like you can have a reparole as well as a TPS. Is there like a limitation? Can you have 2 active EADs? And like all of that is until you get to the stage of AOS, and once you're adjusting, then you have just one status. You don't have like.
Correct. Your understanding is correct. So you can have, let me give you all the pathways I can give you. So like with Afghans, we did asylum, and SIV and TPS and reparole, like you said. I did 4 cases for each of them to get to the answer. I mean, let me tell you, it's because we had a lot of funding for Afghans and it's a special situation. You don't feel like you have to do it, but yes, the option is available to you, that you can have those. The EADs is a little more nuanced, but it would be, I would argue that the EAD controls whichever one expires the latest. I would say that's my EAD. So say you just got a reparole EAD that's good through 2025 and your asylum one's only good through 24, I'd start presenting my EAD. You can't have 2 EADs of the same category. They're going to revoke one. But like if one is C11 and one's C8, that's okay.
So you can have 2 current EADs in different times.
Yeah. I mean, they're not going to know because they don't talk to each other. But yeah.
What about if one is like a student that has restrictions and then they want to do a C8?
Well, then I would use the C8 one. I mean, they can do that. I would use the C8 one to work.
Will it affect their
Well, that's a good question. That is not, I don't know hardly anything about student visas, like if I really thought about it, but I usually advise that they talk to their international student advisor at their university to talk about it. Because especially they might have like employment restrictions, and I'm not sure how that affects their student status. Okay. All right, let's talk about inadmissibility and deportability. Okay. Inadmissibility would be a ground that prevents you from being let into the United States or to adjust status, right? So if you're already here and you have a green card and you commit a ground of inadmissibility, oh well, you're probably not going to get removed from the United States. Versus a ground of deportability, which would get you placed in removal proceedings and potentially removed from the United States. Okay? Let's talk about general grounds of inadmissibility. Health grounds. So you have a disease of significant communicable disease, you may not be let into the United States, or you may not be approved for adjustment status. It used to be like HIV was one, it's no longer a ground, it's not a Class A medical condition, which would prevent you from being let into the United States. I actually don't know off the top of my head any Class A medical conditions, but now I'm curious, and now I'm going to look it up, but I don't, do you know one?
Sexually transmitted diseases.
Oh, okay.
So especially gonorrhea and syphilis.
Okay. But once you get treatment, you should be. TB if you're untreated.
If it's untreated.
TB if you're treated is. Criminal, yeah.
So, I just want to make sure.
Yeah.
I understand, right? So if you do have an STI or STD, you're not allowed.
Without treatment, an untreated one. So if they were to detect gonorrhea and you weren't undergoing treatment, then you would be inadmissible. But as long as you're, typically with Class A's, as long as you're receiving treatment, and your treatment might look different, right? A lot of foreign nationals test positive for TB because of the way they test positive on skin tests because of the way they're inoculated against tuberculosis. They don't often have TB, but people can come in with TB as long as it's actively being treated. And they have, literally, we had, like the health department usually has to watch, like go to their house every week and watch them swallow the pill. It's very weird, but that's how they are in compliance with their immigration matter. Yeah, but good question. Again, criminal reasons. There are criminal grounds for which you may be inadmissible. Had a green card interview for a gentleman from the Congo. Nope, Sudan. Last couple weeks ago, and refugee gets a green card interview. Not a good sign. What did you miss? We went over, have you ever been in the back of a police car? All these things. No. The officer straight up told us it's because he has an arrest in Sudan, which we didn't pick up on, which he didn't tell us because he thought, oh, it happened in Sudan. So there's another question I'm going to ask about. Here, ever, anywhere in the world, anytime. Because he admitted to it, he talked about what happened. It wasn't that he was deceitful, it's that he didn't think it mattered because it happened, and it was part of his persecution in relation to why he became a refugee, right? And it's been vetted before, so he was like, well, I don't know what this is about. So they had to re-ask some questions, but it was fine. So that might be a reason that they're inadmissible to the United States, or why they might not get granted adjustment of status, is if they have criminal backgrounds, not just here, but in their home country. They're a threat to national security. I feel like this feels fairly obvious, and we probably don't need to go into depth, but you can potentially fight threats to national security if you have, I don't do this, but if somebody's found to be inadmissible overseas because they're a threat to national security, there are ways to fight that, mostly litigation. You probably like sue the Department of State, but no, I don't do that. Okay, I don't do labor certs, so if they don't actually have a labor certification, this is like I-140s if you do those ever, which you probably don't. I just like skip over this because I don't really understand labor certifications. If there's been any fraud or misrepresentation, so they claim to be married to this person, then they find out it's all been a big ruse and this person's not actually married, or they misrepresent. There's misrepresentation, but it does have to be misrepresentation of a material fact. So if they said my car was blue, but it was actually red, is that technically a misrepresentation? Yes, but does it matter? Absolutely not. So if you get a denial, because this happened once in an asylum case where they were like, they said the people were driving, it's not necessarily ground of admissibility, but let me tell you about a misrepresentation situation. Said the client, the persecutor was driving a black truck, but then later he said it was a red truck, and they denied the asylum based on this. Well, we got it reviewed, and they were like, that's dumb. That's not a reason to deny, because somebody, when they were being chased by somebody, couldn't remember if it was a black or a red truck. That's not, ground. So similar, unless the misrepresentation is not of a material fact. So I had 3 TVs in my house, but really only had 2, things like that might come up during a marriage-based adjustment. If they have prior removals or unlawful presence, this is when 3 10-year permanent bar comes in, that's a ground of inadmissibility, and miscellaneous others, because they can make up what they want and say, this is a ground of inadmissibility now. They can say, well, we don't like you because something. This is a random ground of inadmissibility. I'm going to claim miscellaneous inadmissibility. Problem is you don't often know, especially if they're overseas, they get this like generic handout that's like, you have a 237 issue. And it's like, oh, well, thank you. Can you tell me which ground of 237 that I'm inadmissible under? Nope, sure won't, and you can't get more information. There is a way to communicate with the embassy's counsel sometimes. If you really think it's an erroneous denial, it's called LegalNet. You can communicate LegalNet. You can email them and basically say, I think there was a erroneous legal determination made here in a consular processing matter. They were found ineligible under, maybe it's a misrepresentation thing. They're under 237 misrepresentation, but they're saying it was this isn't material, here's why. And then sometimes that LegalNet will go and advocate with the officer, the consular officer themselves. Questions about inadmissibility? Woo, okay, I had too many. Oh, look, I had slides explaining it all. I'm just gonna run through this. I was like talking about it, okay. Still, a health ground of inadmissibility may be not getting COVID or flu. Mind now, flu is required during flu season, and they, as of last week, had to have the new monovalent COVID vaccine as importer to be admissible to the United States. Any kind of physical or mental disorder that's a threat to others, or drug abusers or drug addicts. Guys, I don't know why I forgot that I had all these slides. Like, I just looked at this last night. So, any crimes involving moral turpitude is a ground of inadmissibility. Theft is a crime involving moral turpitude, even if it's like a $10 shirt from Kohl's. So, this is why we ask criminal ground questions. So, have you ever been arrested? Yeah, one time I was arrested for shoplifting. Put the brakes on. You need to go see a crimmigration attorney, because any grounds for theft, no matter how much it was, is a crime involving moral turpitude. Okay. In national security grounds, again, obvious. Any person labeled by the U.S. government as a terrorist. I would also argue in relation to Afghans, we now need to be careful that any affiliation with the Taliban would be a ground of inadmissibility, because the Taliban is per statute, a terrorist organization. So there is no arguing that the terrorist group is not a terrorist group, because Congress said they were, like in a law. So sometimes with a what we call a trig ground, so terrorism-related inadmissibility ground, we can argue that the group isn't really a terrorist organization because they're the government of that country or something like that. But that will not fly with the Taliban. So be aware of any association with even, this is one of the hard parts with the Afghans. Even the Taliban is the only person who owns a grocery store in my town, and I had to buy groceries at the Taliban-owned grocery store. Technically, that's material support of a terrorism group, and I think you could potentially get hit with a trig ground. I don't know for sure. I think there's got to be understanding people out there, but I think you need to be very careful when you're working with Afghans about even with a gun to their head, doesn't matter. So you need to be careful about any association with Afghans, with any Taliban folk. So did they have to go get a passport now to travel? Did they pay the Taliban, the de facto government, money for a new passport? Maybe that's a trig ground. I think you're gonna see some litigation on that in the coming years as this happens more and more. But I'm very concerned about that.
Well, those are very specific questions in the asylum review as well.
Yes. Yeah. There are very specific questions. I have a woman her husband was killed by the Taliban. They held his body for ransom. She wanted it, so she paid them. And now I'm afraid she's not going to get asylum because she paid the terrorists for the body back. Even though it feels like, of course you're going to do that. What are you going to do, right? So, yeah, I know, it's hard. Okay, also, if they ever participated in Nazi persecution, they're subject to a ground of inadmissibility. I don't know about you, but 99% of my clients were not alive during Nazi Germany, so I usually skip that question on the 485. It's between 1943 and 1945, were you a member of Nazi Germany? And I say 99% of the time, no. Okay, public charge of inadmissibility. So let's talk about this a little bit. There has been confusion among attorneys on the 485 form where you check the box, are you subject to the ground of, I don't remember exactly how, are you subject to the public charge ground? When you check that box, it does not mean you think you are going to be a public charge. It means you are of a visa category that is subject to that ground. So refugees, not subject to being a public charge per the statute, so you check no. They're in a marriage-based adjustment, you need to check yes, fill out the rest of the boxes about income, but it does not mean you think they're going to be a public charge. It just means they are theoretically subject to this, but you've presented the other income and proof of that they are not going to be a public charge, but that they are theoretically required to provide that documentation to prove they won't become a public charge. Yeah.
So when you answer all those questions about their income and stuff, do you include whoever's sponsoring them income when you answer those questions?
Let me think
Right,
about that.
because-
Yes. Yeah. Sorry, had to think about it for a second. It's like reading the form in my head. Yeah. Yes. Good question. Yeah. Other questions about the public charge? It's not as like crazy as it was during the Trump administration, but it's still theoretically a thing. But most of the time, if a person's eligible for emergency Medicaid or something like that, that is not a public charge ground, so they're not going to be tagged for that. ESO, emergency services only Medicaid, is not subject to a public charge. Okay? I'm going to skip labor certification. Okay. Theoretically working without permission is ground of inadmissibility. Reminder, they're only grounds of inadmissibility if somebody says they are. So these are all the theoretical ones, but if they aren't charged with a ground of inadmissibility, then they've waived that requirement for them. Okay. Misrepresentation we talked about. let me repeat the 3 and 10 year and permanent bars again. So 3 years, if you enter the United States, even with a visa, but you overstay for less than 180 days, so you're present without admission for less than 180 days, you're subject to a 3-year bar, which means you have to wait 3 years before you can apply for another benefit. Interesting, there was some case law this year that said that person can wait 3 years inside the United States before applying. So that 3-year and 10-year will toll in the US. 10 years is if you're here for 181 days or more, then you are subject, 300 and, let me back up. Less than 180 days, there's no bar. I said that wrong. 181 days to 364, there's a 3-year bar. If you're here without permission for 365 or more, you're subject to a 10-year bar. If you've ever been subject to a bar, you leave, or if you've ever entered without permission, left and re-entered without permission, you're now subject to a permanent bar. Permanent bar is theoretically waivable, but only after 10 years. So they have to go outside the US for 10 years, then they can apply for a waiver to the 10-year bar. But it does not mean that they can just apply for an immigrant visa and come to the US after 10 years when they're subject to the permanent bar. They have to apply for a waiver to the permanent bar. Okay, miscellaneous grounds of inadmissibility. So they enter without inspection, theoretically smugglers. Smugglers has also been applied to parents bringing their children. I hate it. It's not a real thing, but that has also been a ground that's been applied. You're being charged with a ground of smuggling because you helped bring in your minor child to the US. Polygamists who are practicing are theoretically. Now, Afghans, I tell you, that's just like a unique population. There were many an Afghan who came in with many wives, mostly 2, who actually entered the United States with both wives. So I don't know how that works because I haven't adjusted any of those folks. But I have a feeling it's going to come up and they're going to have to address it. But the U.S. also evacuated them knowing that they were bringing both wives. So, it's a thing. If only one wife is in the U.S., I think you can reasonably argue that they're not actively practicing polygamy because they only have one wife here in the U.S. So we have that situation a couple times at work where we have a couple wives, one wife at home, one wife here. So I had a client ask me one time if he could just bring his favorite wife, which was wife number 3. And I was like, no, sir. It's not how that works. Because remember, the first wife is the actual, in terms of U.S. law, I don't want to put I don't want to appropriate my own culture on other people's culture because that's okay. If it's okay in their culture and everybody, whatever, is a consenting adult, I don't care. But in the U.S., the first marriage is the legal marriage. Every other marriage is what we call void. Void ab initio. So at the point of the second marriage, it means it never existed, really, because it's against public policy. Void is against public policy. So, guys, that's all I have in terms of slides, but we still have half hour, so let's talk. Yeah, ask me all the questions.
Can we go back to the inadmissible issue about vaccines?
Sure.
And especially the COVID vaccine. We have a large Ukrainian enclave in our area. And we are getting more and more refugee adjustment clients who are coming in and telling us they are not going to take the COVID vaccines because they're against it.
Okay.
And we show them the USCIS policy and they say, we don't care, we're not going to take it.
Okay,
So
well,
we're telling them,
then they're
sorry, we
probably
can't
not
help
going to get their green card
Right,
unless they can show an actual religious exemption or a health-related exemption. There are exemptions available. Have I filed one? No, because it doesn't feel like it's worth my time.
We had one client that filed it, our first one, because her argument was when she filed her original 485, COVID was not required. Her I-693 medical expired, so she had to take it again, and then she saw that the COVID. She actually went to an interview, and this was very unusual. The USCIS officer called us after the interview.
Interesting.
To say, personally, I'm against the COVID vaccine myself, but there is no option for your clients who refuse to take it. And furthermore, her argument of religious exemption. She had a letter from her pastor. The officer said, that's
No
not
go.
good. That's not good enough. It has to be a very compelling reason why they cannot take it.
Yeah.
And he mentioned some medical reason.
Yeah, like I have a colleague that has a genetic abnormality that prevents them, so that would probably be like fine. But I don't know. I mean, my answer, I think there's a lot of vaccine hesitancy among immigrants. Like there's vaccine hesitancy in this country, and that's fine. But in particular, like I see it a lot with our Africans, that they just like don't want to get the vaccines. I think there's a history of trauma related to vaccines and medical care with Black folk and with Africans. And so I want to be mindful of that, but I also think like this is the line, right? Like this is what immigration says you have to do. You can exist permanently as a refugee. Like you can live, I mean you can, right? If you refuse to get the vaccine. So your choice is either without absent a very good cause, a medical cause, or, I mean, I don't think there's been very many successful religion because there's been so many churches that have been like, you know, like you can't be Catholic and say, I don't want to get the vaccine when the Pope said, it's okay to get the vaccine. Like, you know what I mean? Like they're not going to take your word for it because my particular form of Catholicism says I can't get the vaccine. What we've been telling clients is it's a requirement. If you want your green card, you're going to have to do it. People don't want to get the flu vaccine either, but they have always, I mean, for the last 10 years, have had to get their flu vaccine during flu season. So I don't know what to tell clients other than, frankly, I have too many green cards to do to fight with people. Like you either have to do it or you don't. But I mean, if you don't want to do it, that's your decision. But I can't in good conscience file this knowing that we're going to get this RFE and I'm going to have to fight it again later. So.
But I hear you saying that refugees can remain in that status for...
Yeah, I mean, refugee status is good indefinitely. Are they supposed to apply for a green card? Yeah, but if they choose not to, I guess. The risk at not adjusting for a refugee is that theoretically their country improves. They could be removed back, you know, oh, everything's fine in Burma now, you can go back to Burma. That's the risk. But is it likely? Has it ever happened? No. But also, please don't let it happen. So, yes.
Back to asylum.
Yeah, she had her hand up over here. That's okay. Go ahead.
For the 3 to 10-year permanent ban, what happens if it's a childhood arrival, like an underage person who overstayed their visa, but it wasn't?
Before they turned 18?
Yeah.
They don't accrue unlawful presence if they are under the age of 18. So good question. So if they came in with mom or dad, were here for 3 or 4 years, then applied for DACA before they turned 18, they've accrued no unlawful presence, and they can... They would likely not be subject to a bar, I would say. But I think it would depend on the individual circumstance. So, sure.
If they came in as a baby, EWI, left, returned, EWI, the permanent bar, and then they got DACA, they would still be under.
I don't know. It really is so fact specific. It also would depend on if they entered like pre-IRA in 1996. Like when did they enter? Were they subject to that bar initially? You know, like it's really hard to say without getting into the nitty gritty facts whether that person would be subject to the permanent bar. I think you need to, even if you're like, well, I think you're probably not subject, you always need to warn about the permanent bar, the 9C bar.
But generally, under 18 does count for the permanent bar, right? Even though it doesn't.
I think you're right. Yeah.
Yeah.
Yeah, I think you're right. But they don't accrue unlawful presence for 3 and 10, but I do think you're right. It counts for permanent bar.
The only one that doesn't matter your age.
Yeah.
It's that second entry. If that second entry is EWI, then you're up for creep. But if that second entry was on a visa, you're fine.
Yeah.
Well, but also I think
That
depends on
includes
whether,
the INA.
yeah.
So I've argued that one with USCIS.
Great. So, there you go. He wants to go on to asylum. Do you have another question that's not asylum? Okay, yeah.
You made a comment that they could wait it out here.
There's a new rule that they can toll it here, yeah.
So it wouldn't then kick into like a 10-year bar because they're still
I think it's both 3 and 10.
Both
Yeah.
can be served inside the US.
No.
But I'm assuming in that situation, they have to have lawful like a parole or a TPS or something, because if they
I don't
didn't
think so.
have status, then they were.
So that's what I'm asking, like, if they're, you know, if they're up here for 180 days and then they're here for 280 days, they wouldn't suddenly go the 10-year bar?
Yeah, what
Like-
keeps them from getting that?
Say your question again.
Okay, so if they're here, and you're saying, you know, they have unlawful presence less than 180 days, but.
So then they're not subject to a 3-year bar. If it's less, I messed up my statement to begin
Okay.
with. So let's go less than a year.
Less than a year.
Uh-huh.
So less than a year, they are subject to the 3-year bar.
Uh-huh.
And then they wait it out while they're here, but they're gaining more.
You're right. They're going to be subject to the 10-year bar.
So it would just be 10 years.
Yeah, essentially. Yeah, you're right. Unless they get into it like a status.
So if we've had clients who have been here for a long time,
Mm-hmm.
but haven't left, but haven't accrued all this unlawful presence, but it's been more than 10 years, we can move forward with their, like, whatever.
I think that's probably beyond my understanding of the 3 and 10-year bar at the moment. I'm happy to give you my card, do a little bit more research, and we can talk about it. But I don't want to speak to that here because I just don't deal with a lot of 3 and 10-year bars in my practice because I mostly deal with refugees and asylum seekers. So it doesn't come up a ton for me, but I would like to get you the answer to that question. So I will give you my card, and I will do some research, and I will let you know.
Thank you.
Sure.
I also have the original email clinic sent last year when that new policy came out. So I can forward that on to those who may not have been in front of clinic last year.
Great. Okay. All right. Ready to turn to asylum? Go.
So supposedly, we got several people come in that went to their first court hearing, and either a judge or a court official has given them a I-589 and said, go get this filled out and come back to the next appointment.
Mm-hmm.
And they're wanting us to help them fill it out. And obviously, as a preparer, not extending beyond that,
But you're not licensed to practice before EOIR, right? Okay.
Right, okay, so, right. I want the answer to things, don't do it.
Only if are you an attorney?
No.
Are you fully accredited? No. Only E61s can be for an attorney or fully accredited rep. I do E61s. I do it for people.
So that one is not going to USCIS at all.
Right. If they're in removal and a judge has said to them they need to fill this out, they need somebody who's licensed to practice in front of EOIR to advise them on how to fill it out. That is my recommendation. Oh, that's the answer you wanted. Great. Yeah. Sure.
We had a client from Russia
Mm-hmm.
who basically, when the war happened, left the country
Mm-hmm.
because one of his friends was serving from the Ukraine side who was killed, and he was getting all this questioning by the police in Russia. So he was like afraid of his life and came to US.
Okay.
He was paroled by CBP, and the I-94 status said DT.
DT?
Yes.
Okay.
It was for 2 years,
Yeah.
which is usually for Ukrainians.
Yeah, but CBP does what they want.
Yeah, but like for Ukrainians, if you have a DT category I-94 for 2 years, you can work on that.
For anybody who comes in with a DT category.
So he doesn't have to file a 765, he can work on that.
Oh, I see what you're saying. No, he needs to file a 765. I'm sorry, I understand. I misunderstood the question. Yes. So he can file a C11 EAD. Anybody who enters on DT, generally for a year or more, because that's how long it's going to take to get it, can file for an EAD. But no, he can't work just with that. Good question. I'm sorry, that was my misunderstanding.
Next question was about DS 4317.
For Afghans?
Yes.
Sure.
Parolee families. That form was taken off in August.
Yeah, I think it's back now, as of like late last week.
It looked like it was not one form anymore. It was like, oh, if you're an LPR, is that what it was?
Yeah.
Before? I didn't ever see it.
Yes, it was like that before too. Yeah. So DS 4317 is what is that, like family reunification option for Afghan parolees. But it's not actually family reunification, it's like an evacuation flight to a third country, and it's complicated. And have I seen any be successful? No, not yet, but my client did get a call a couple weeks ago, and apparently there were maybe 2 or 3 evacuation flights that left last week. They hadn't left since June. They resumed last week, is what I heard. And I think they're flying them to Qatar. Okay. Do you have anybody want to ask me any other questions about all kinds of things? I got many a knowledge. Just kidding. Go ahead. Sure. Go ahead.
So this was actually real life. I would say my brother. So me and my brother arrived here as childhood arrivals.
Okay.
We overstayed our wedding before. He has a mom. When he turned 19, he left the country. Didn't tell anybody. And he was actually eligible to apply for a green card because he was married to his then girlfriend. But he took the money that he needed and just took
Left.
a one-way flight to the Dominican Republic. So then a couple of years later, we decided to buy him a flight, see if he's able to come in, and he made it through immigration, but
Your brother is lucky.
yes, very. The reason why he got stopped was in customs because I love my brother, but sometimes he did not bring not one piece of luggage with him, and so wait a minute. And so I think we were trying to figure out where he was. We contacted our lawyer and everything like that, and I guess he doesn't know because he doesn't literally read what they give you, but I think he did voluntarily deport himself. He did get a 10-year ban. So now he's back in the Dominican Republic. This was years ago, but I'm pretty sure he's getting to the 10-year. My mom's a U.S. citizen. If she does apply or petition for him, how does that affect him in terms of the ban?
Did he take a voluntary departure? Is that what you're saying?
Yeah.
Because a voluntary departure is not a deportation, so it is not subject. So that would not have been a second entry with a deportation.
So he probably didn't get the
He probably has a 10-year bar, but it doesn't. Based on what you're telling me, it does not sound to me like he has the permanent bar. But
How was he?
well, right. You should do a FOIA. Always do a FOIA, by the way. I love FOIAs. You guys do them online. Freedom of Information Act requests, get their files. I filed this asylum. I think there's something going on in the Haitian community where they're sending the first 3 pages to the Defensive Asylum Receipt Center so that it looks like they filed asylum so they can get work permits, but then they didn't actually file asylum with the court. So then the work permits get denied, and it's because you don't actually have a case pending with the court. So I have been filing FOIAs for, if I'm going to help them do a work permit, a Haitian, I'm I need a file stamped copy of your court paper. And they're oh, this is what I have. And it's Defensive Asylum Center. I'm I want a FOIA to make sure the whole thing got filed. Because what I think is happening for probably a TikTok thing, they're going to send the first 3 pages, which you have to send to complete biometrics. And then they use that as proof that they've been here, and then they file for a work permit at 180 days. And then the work permit gets denied, and then they're why did it get denied? And it's because they didn't actually file asylum. So.
Well, speaking of, I guess working with
Okay.
I guess dealing with applicants and SIPs. I filed work permits. They have approved SIPs, but they're getting some that have been denied. One has gotten an automatic extension.
Which work permit got denied? The SIV one?
Yes. That one and one for asylum, we're still waiting on the police report. That one was denied as well. I'm not sure.
So I don't often find it's helpful to appeal those denials. I just refile the 765.
Okay.
I don't know if you ever do that, but I don't find it helpful at all to appeal denials of 765s. It's a waste of, that 290B fee is too expensive, and I'd rather just refile, especially in the case of Afghans when they really don't have to pay the fees. I just refile the 765. I would do it urgently though, because that fee exemption ends in 4 days. So the fee exemption and the prioritization of Afghans for asylum ends on September 30th at the end of the fiscal year. So, and there's no, so what it means, doesn't mean they can't apply for asylum, doesn't mean they can't apply for a work permit. Doesn't mean they have the statutorily eligible fee exemption. And it means their cases, Afghan cases, which for the last 2 years have been prioritized at the affirmative level, right? Where they've been filed, 6 weeks later they get an interview. They will start going to the back of the line. It will be 6 or 7 years before they get interviews now for the Afghans if they file after. They're
6 to 7 years for different.
after, if they file after September 30th. Yeah. So I know you can't do much about it while you're here, but if you have people back, okay. So we, I think that's something to be aware of related to Afghans and asylum. So, yeah. Sure.
I just want to confirm something. Someone told my site director that as commercial DOJ reps, we can't handle any asylum cases, but we can help with affirmative ones.
Yes. Yes. You can, okay, because remember, affirmative asylum is before DHS, and you're licensed in front of DHS. You are not licensed in front of DOJ, which is EOIR. So that's how I think about it. If it's within DHS, you can do it.
So we can go with them to their interview.
Yeah.
And everything.
Yes, I send my DOJ reps to the interviews. Sure.
What about LGBTQ communities? We've been told that there's an exception for them that come across, there's an exception for that group.
Uh-huh.
As far as affirmative asylum versus defensive on them coming. Yeah.
I have not heard of this exception. There is an exception for unaccompanied minors that come across. Unaccompanied, a UAC with a UAC designation can file affirmatively even if they're in removal proceedings. But that is not, I have not heard of an LGBTQ exception. I'm pretty up to date on stuff, so I feel like I would have heard of that, but you know, who knows? I guess I could be wrong, so. Other questions back here? Okay. No? Okay, guys.
So are we filing for, okay, just back to referral.
Yeah.
If they already have approved asylum or SIV,
They don't need a reparole.
they don't need to file for referral.
Correct.
So you would just file the I-765
Mm-hmm.
and then go on as.
If they haven't approved asylum, they should have got one in automatically. Now, if they didn't, then help them out. But in in that case, I would wait until October 1st to file that, because then they're going to get the 5-year one as opposed to the 2-year one. Sorry that the dates are confusing, man. So, okay. I hope this was helpful to you guys, this one. I think we still have like 15 minutes, but I'm also happy to just like kind of stand up here, and if you have individual questions you'd like to come ask me. If there's any more group questions, that's fine, but I don't think Zach's going to kill me if we finish a few minutes early. So, but like I said, I'm happy to just talk specific cases or general cases. Yeah, that's fine. So I have some cards up here. I also, because I'm always promoting that refugees are welcome, I know you are not all from Indiana, but I have stickers for water bottles if anybody would like to show that refugees are welcome wherever you are. I have some stickers up here as well. So, okay, thank you so much, everyone. I appreciate you.